Welcome to the Boulder Criminal Lawyer Podcast. I'm your host, Elena Nicole, and today I'm here with Ian McDavid. Ian is a Boulder-based criminal defense attorney who has represented thousands of clients and taken over 40 cases to jury trial. And in this episode, we'll be breaking down the real-world legal side of DUI, from what actually happens during a traffic stop to how these cases are built, challenged, and decided on in court. So Ian, I'm really looking forward to this conversation. Let's dive right in.
Yeah, thanks for having me, Elena.
So let's talk field sobriety tests a bit, because I think there's a little confusion over whether these are required and how they work. So are field sobriety tests mandatory, and how reliable are they as evidence?
They are not mandatory. In fact, the law enforcement officer is going to tell you that they're voluntary, and they're designed for you to fail them. They were theoretically validated back in the 70s through some scientific experiments, but they're set up to fail, right? So where you or I go through the world and like you go to school and maybe the teacher's explaining like what do you got to know, what do you got to do for this thing, you don't think you're being graded when the teacher's explaining the project, right? But yet the law enforcement, as soon as you say, yeah, sure, I'll do the maneuvers, they start looking at every single thing that you do, and they don't tell you what you're being graded on, right? So you assume it's going to be walking in a straight line, and sure, that's part of it, but they're not telling you that they're looking to see whether or not your hands come up off your sides. They're not telling you that the cute little trick step that they do when they turn in a circle, that is actually something that they score, and if you don't step exactly the way that they step, there's a point off. And that's for the walk and turn. The horizontal gaze nystagmus test, which is that one where they put the pen back in front of your eyes, that one does have a bit of a scientific basis because it's based on a physical and observable phenomenon, which is this jerking in somebody's eye where they're drunk and then their eye starts jerking around at the extremes. But with respect to those roadsides, you are not going to pass them. I mean, even if you're sober, I think a lot of people aren't going to pass them. You'd have to be paying eagle attention to that law enforcement officer, probably done them before, and you'd be surprised how many police officers I've seen on the stand screw up the demonstration of these maneuvers. It's real common how that happens. The point of all of that is they're voluntary. Don't do them. Don't give them more information to help you get yourself in trouble.
Interesting. Is there ever a time you should do them?
No, I don't think so. I mean, unless you're so confident that you're sober that you're just trying to screw around, in which case, have fun. But even then, don't do that either. That's a dumb idea.
Yeah, absolutely. So really, it works against you more if you do choose to do it most of the time. Is that what I'm saying?
That is what they're set up to do. And to think about it like this, right? They were designed in the 70s when we had some real problems about proving how a person was acting, right? Like we didn't have body cameras in the 70s. We had to rely on what law enforcement saw. Now, with body cameras attached to every peace officer in the state of Colorado, and they have to be running or you got bigger problems than this, those body cameras show your behavior way better than the roadsides can. Mm-hmm. And so, rather than like, oh, well, did he pull his hand up or did he fall over? I mean, when I watch the body cameras nowadays, I'm really not looking for the clues as much as I'm looking for, does the person seem like they're screwed up or not? Because that's exactly what a jury's going to do.
Yeah, absolutely. Well, that's really good to know. So let's talk acronyms. DUI, DWI, they can be confusing to people, what they really mean. So can you tell us what is the difference between DUI, DWI, DWAI? Am I forgetting any of them?
Maybe. So there's a couple different there's really three different sort of crimes that you can get. And I'm not counting the second, thirds, fourths and all of that. Mm-hmm. But there are two kinds of DUI. So the first kind of DUI is driving under the influence. That is the crime of driving when your ability to operate a motor vehicle is substantially impaired by the use of alcohol, drugs, or both. Substantially impaired is the operative term there, right? You need to be substantially impaired, right? There's got to be a real problem with your behavior. The other thing that we know of as DUI, and this is by far the more common one, is what we call DUI per se. In that analysis, the substantial impairment thing doesn't matter. What matters instead is whether or not that blood or breath testing reveals a BAC higher than 0.08. For either of those, if it does, that's the crime. And it doesn't matter, you could be Lewis Hamilton and be at a 0.09, and I guarantee you Lewis Hamilton at a 0.09 is probably a fine driver. He's still guilty of a DUI. Like, it has no bearing on your ability to drive. It has no bearing on any of that. It is simply a question of, is your BAC over the line?
Right.
Now, The sort of the flip side for both of those is the third one, and that's DUI or DWAI, driving while ability impaired, or DWAI. That is the lesser offense. It's where you're driving and you're impaired to the slightest degree. We call that's like those road signs. High driving is buzz driving, or buzz driving is high driving. Those kinds of things. There's not really a line for your BAC for a DWAI. Technically it's 0.05, but most people instead just go with, did the person seem impaired at the time? Now that offense is lesser, which means it's got fewer community service hours associated with it. It's got fewer fines associated with it, and that's all good. But the penalty is basically the exact same as a DUI. So you're still going to have to do a year of probation at a minimum. You're still going to have to do all of the classes that are required by law. You're still going to have to pay some fines. You're still going to have to do the DUI therapy as well. And all of that stuff is the big expensive thing. Really, the only difference between them is the points and the fines.
The points. Okay, and that was going to be my next question, is what are the typical penalties? And it sounds like they're similar for all. Did you just list all of them, or did we leave anything out?
I think I probably left some out. So
okay.
the penalties for a DUI, and I'll just kind of describe generally what a person gets. So if it's their first and it's not a very aggravated case, in other words, there's no accident, there's no, it's the BAC is not sky high, things like that. You're looking at likely a prosecutor offering you a downgrade from a DUI to a DWAI. That is an 8-point ticket. It comes with it's not actually required, but pretty much every judge in the state is going to give you a year of probation as a condition of that you're going to get level 2 track B at a minimum classes. And that's a class and therapy component. That's where a lot of that expense from the DUI comes from, or those classes. Everybody has to do community service. That's required for a DWAI. It's a minimum of 12 hours. For a DUI, it's a minimum of 24. I believe it's up to 96 for the DUI. Those are also required, and a DUI is 12 points.
Mm-hmm. Okay.
For both of them, you have to get what's called a Mothers Against Drunk Driving Victim Impact Panel. And then there's also going to be the administrative consequences to your license.
Yeah. Okay. And as far as reduction, is the lowest that someone could ever get it reduced down to a DWAI?
Kind of yes and kind of no. So by law, prosecutors cannot dismiss DUIs. If your line prosecutor at the DA's office that's handling your case, if they think as a lawyer that they can prove your case, they are not allowed to dismiss the DUI. So it doesn't matter what you do for mitigation. It doesn't matter, how much of a good excuse you had. They can't dismiss it. But the exception to that rule is if the prosecutor cannot say to the judge that they can prove a case of DUI here. And that comes up in a few circumstances, right? And I call this the either the wet reckless or the smoky reckless.
Yeah.
A couple times I've gotten a wet careless or a smoky careless. And when I say wet or smoky, I'm talking about alcohol or THC there. And that happens when you've got a major problem with the case, right? So something like law enforcement screwed up the testing process and they don't have a blood test or a breath test, and they don't have a good evidence of bad driving. That's the kind of thing where I look for those, because the trade-off becomes maybe my client goes and does those classes and they learn something, but they're not getting the lifetime consequence of a DUI.
Wow, this has been a great conversation. Is there anything else that you think would be really helpful for people to know that we didn't cover kind of in these little categories of topics when it comes to DUI?
No, I think I covered it.
We covered everything. Thanks, Ian. Again, this was a great conversation. Thanks to everyone listening, and we'll see you next time.